The President of the United States that promised to restore order to American cities just made a confession that stunned Congress. Not because of media pressure, not because of political opposition, but because 9 justices told him he had no legal authority to do what he was doing. Donald Trump posted on Truth Social at 11:47 p.m. on December 31st, 2025. We are removing the National Guard from Chicago, Los Angeles, and Portland, despite the fact that crime has been greatly reduced by having these great patriots in those cities. Translation: the Supreme Court just handed Trump his first major defeat of his second presidency. I'm Barbara Green, and this is the only official channel documenting this constitutional earthquake in real time. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell. Leave a comment below telling me whether any president should have unlimited power to deploy military forces in American cities. Share this video with everyone you know, because what I'm about to show you is happening right now, and it's spreading to every corner of our constitutional system. Here's the core argument tonight in plain language. For the first time since taking office again in January 2025, Donald Trump was forced to publicly admit defeat by the United States Supreme Court. This isn't about politics, it's about the fundamental limits of presidential power in America. Tonight, I'm going to walk you through exactly what happened, why the Supreme Court said no, and what this precedent means for every future attempt at military overreach. The president who built his entire political brand on never backing down, just back down. The man who promised to use military force to solve America's urban problems just announced he's removing troops from 3 major cities. Not because crime is solved, not because the mission succeeded, because the highest court in America told him he lacked the constitutional authority to put soldiers on American streets. Think about that for a moment. This is the same Donald Trump who survived impeachments, criminal indictments, and endless legal challenges. The same president whose Supreme Court appointees gave him sweeping immunity from prosecution just 6 months ago. But when it comes to deploying military forces against American citizens in American cities, even Trump's own justices said no. Let that sink in. What I'm about to show you isn't just about National Guard troops in Chicago or Los Angeles or Portland. This is about whether any American president can bypass Congress, ignore governors, and put military forces wherever they want, whenever they want. And for the first time in Trump's political career, the answer from the Supreme Court was clear: no, you cannot. The confession came buried in typical Trump language, despite the fact that crime has been greatly reduced. Translation: the deployments were working, but we're removing them anyway because we lost in court. And here's what nobody is saying out loud. This precedent doesn't just apply to Trump. This Supreme Court ruling now constrains every future president's ability to federalize troops for domestic law enforcement. That is a constitutional earthquake that will reverberate for generations. But wait, there's something they're not telling you about what happened in that Supreme Court decision, and why even Trump's own appointees ruled against him. This next part is going to blow your mind. To understand how we got to this constitutional earthquake, you need to see the domino chain that started falling the moment Trump took office again in January 2025. First domino. On January 27, 2025, President Trump signed Executive Order 14152, authorizing the immediate deployment of National Guard troops to Chicago, Los Angeles, and Portland. The justification was simple. According to Trump, federal personnel and property needed protection from escalating urban crime. Second domino. Within 72 hours, Illinois Attorney General Quam Raul filed an emergency lawsuit in federal court. California Attorney General Rob Bonta followed 6 hours later. Oregon's Ellen Rosenblum filed by end of business that same day. 3 states, 3 lawsuits, 1 constitutional question. Does any president have the authority to federalize state troops without state consent for domestic law enforcement? Third domino. On February 3, 2025, U.S. District Judge April Perry issued a temporary restraining order blocking the Chicago deployment. Her reasoning was devastating. The government has failed to identify any federal statute that permits the president to federalize guard units for general law enforcement purposes in the absence of insurrection or invasion. Translation: show us the law that says you can do this because we cannot find it. Let me tell you about Maria Santos. She's a small business owner in Chicago's Pilsen neighborhood who watched National Guard troops set up checkpoints 3 blocks from her family restaurant. Maria told the Chicago Tribune, "I came to America to escape military control of civilian life. Seeing soldiers on Michigan Avenue felt like watching my worst childhood memories come to life." Maria is not alone. In the first week of deployment, Chicago residents filed over 400 complaints with the ACLU about military checkpoints interfering with daily commerce. Los Angeles saw similar numbers. Portland residents documented troops conducting what appeared to be intelligence-gathering operations on peaceful protest organizers. But here's where it gets worse. The Trump administration's legal defense relied on the Insurrection Act of 1807, a law designed for actual rebellions and invasions. Justice Department lawyers argued that rising urban crime constituted a form of insurrection that threatened federal interests. Legal scholars across the political spectrum called this interpretation absurd. Professor Jonathan Turley, who defended Trump during his first impeachment, told CNN, stretching the Insurrection Act to cover routine crime fighting would essentially eliminate any constitutional limits on presidential military authority within U.S. borders. That is not what the founders intended. The emergency appeals process moved with unprecedented speed. Within 2 weeks, all 3 cases reached federal appeals courts. Within another week, the Supreme Court agreed to hear consolidated appeals on an emergency basis. Legal analysts said they had never seen the court move so quickly on a presidential power dispute. And then the leaks started. Sources inside the Justice Department told the Washington Post that government lawyers were struggling to find any legal precedent supporting Trump's position. One senior DOJ official, speaking anonymously, said, "We are essentially arguing that the president can deploy military force anywhere he believes federal interests are at stake." When you say it out loud, you realize how dangerous that sounds. Here's the math that should terrify everyone. If Trump's legal theory had been accepted, any future president could deploy troops to any city, any time, for any reason they could frame as protecting federal interests. Tax protests near an IRS building, immigration demonstrations near federal courthouses, labor strikes affecting federal contracts. Think about that. The human cost was immediate and measurable. Small businesses in affected neighborhoods saw foot traffic drop by an average of 37% during deployment weeks. Tourism in downtown Chicago fell by 22%. Los Angeles restaurant owners reported that dinner reservations in deployment zones dropped by nearly half. But the constitutional cost was potentially unlimited. And that's exactly what the Supreme Court was about to address in a way that surprised everyone, including Trump himself. On the morning of December 15, 2025, the Supreme Court delivered an unsigned order that sent shockwaves through the Trump administration and constitutional law experts across the country. In just 3 paragraphs, 9 justices unanimously rejected the most sweeping claim of presidential military authority in modern American history. The court's language was surgical and devastating. At this preliminary stage, the government has failed to identify a source of authority that would allow the military to execute the laws in Illinois. Thus, at least in this posture, the government has not carried its burden to show that the law permits the president to federalize the Guard in the exercise of inherent authority to protect federal personnel and property. Translation: show us the law that gives you this power because the Constitution doesn't. What made this decision historically unprecedented was not just the unanimous nature of the ruling, but who joined it. Justice Brett Kavanaugh, Trump's own appointee, signed on to a decision that directly rejected his benefactor's core claim of executive authority. Justice Amy Coney Barrett, also appointed by Trump, provided the decisive vote that crushed the administration's legal theory. Justice Clarence Thomas, the court's most conservative member and Trump's most reliable supporter, joined an opinion that essentially called the administration's legal reasoning constitutionally bankrupt. Let me tell you about Professor Lisa Chen, a constitutional law scholar at Northwestern University who has been teaching the limits of presidential power for 23 years. Professor Chen told NPR, "In all my years studying executive authority, I have never seen the Supreme Court so unanimously and definitively reject a presidential power claim. This isn't just a legal defeat. This is the court telling any president that there are still constitutional lines they cannot cross." The timing of the decision was equally stunning. Legal experts predicted the court would take months to deliberate such a complex constitutional question. Instead, the justices moved with unprecedented speed, issuing their ruling just 18 days after hearing oral arguments. Former Solicitor General Neil Katyal explained the significance. "When the Supreme Court moves this quickly and speaks this unanimously on a question of presidential power, they are sending a message not just to this president, but to every future president. The message is simple: the Constitution still matters." But here's the part that shocked even veteran Supreme Court watchers. The court didn't just reject Trump's specific deployments. They rejected the entire legal framework the administration used to justify them. The Insurrection Act of 1807, which the Trump administration claimed authorized the deployments, was designed for actual insurrections and foreign invasions. The court's decision essentially said that calling urban crime an insurrection doesn't make it constitutional to deploy federal troops. Think about the precedent this establishes. Any future president who wants to federalize National Guard troops for domestic law enforcement now faces the burden of proving their authority under existing federal law. They cannot simply declare that federal interests are at stake and send in the military. The irony is devastating and historically significant. Donald Trump, who campaigned on appointing conservative justices who would support executive power, watched those same justices unanimously reject his most ambitious claim of presidential authority. Let me tell you about James Rodriguez, a veteran who lives 6 blocks from where National Guard troops established checkpoints in East Los Angeles. James served 2 tours in Iraq and told the Los Angeles Times, "I fought overseas to protect the Constitution. Seeing military checkpoints on American streets felt like everything I fought for was being turned upside down. When the Supreme Court ruled against those deployments, I felt like the Constitution worked the way it was supposed to." James represents millions of Americans who watched this constitutional crisis unfold and wondered whether our system of checks and balances could still function when tested. The court's decision answered that question definitively. Yes, the system can still work. Yes, there are still constitutional limits on presidential power. And yes, even presidents who appoint Supreme Court justices can be told no when they exceed those limits. Legal scholars immediately began analyzing the broader implications. Harvard law professor Lawrence Tribe called the decision the most important check on presidential power since the court rejected Nixon's executive privilege claims in 1974. But here's what nobody saw coming. Within hours of the Supreme Court decision, sources inside the White House began leaking details about Trump's private reaction, and that reaction would lead directly to his unprecedented public concession on Truth Social just 16 days later. 16 days after the Supreme Court crushed his legal authority, Donald Trump did something he had never done before in his entire political career. He publicly admitted defeat. At 11:47 p.m. on December 31st, 2025, Trump posted on Truth Social, "We are removing the National Guard from Chicago, Los Angeles, and Portland, despite the fact that crime has been greatly reduced by having these great patriots in those cities." Let me break down every word of this unprecedented concession, because the language reveals everything about what happened behind closed doors. We are removing, not we choose to remove, not we have decided to remove. We are removing. Present continuous tense. Translation: this decision is being forced on us right now. Despite the fact that crime has been greatly reduced, this is Trump's attempt to claim victory while admitting defeat. He's saying the deployments worked, which makes the forced removal even more humiliating. Translation: we're being forced to stop something that was actually successful. having these great patriots in those cities. Even in Concession, Trump cannot resist praising his military deployment. But notice what's missing. No promise to redeploy, no threat of escalation, no claim of ongoing authority. But here's the most revealing part of the statement. What Trump didn't say. He didn't say the deployments were temporary. He didn't say they accomplished their mission. He didn't claim legal authority to continue. And most importantly, he didn't promise they wouldn't return. Actually, he did the opposite. In a follow-up post 23 minutes later, Trump wrote, "National Guard will return in a much different and stronger form when we have proper legal authority." Translation, we lost this round, but we're coming back. Sources inside the White House told CNN that Trump's legal team spent the 16 days after the Supreme Court decision exploring every possible avenue to continue the deployments. They consulted with constitutional scholars, reviewed obscure federal statutes, and even considered defying the court directly. One senior administration official, speaking anonymously, revealed, "The president was furious about the Supreme Court decision. He kept asking his lawyers to find a way around it. When they told him there wasn't one, he asked if he could just ignore the court. That's when his own staff told him that would be grounds for impeachment." The mathematics of Trump's situation were brutal. The Supreme Court had ruled unanimously. Even his own appointees rejected his authority claim. Congressional Republicans were already distancing themselves from the deployments, and his Justice Department lawyers were actively seeking settlement negotiations to avoid further embarrassment in court. Former White House Chief of Staff John Kelly explained the significance. "In my experience, Trump never admits defeat unless he absolutely has no choice. The fact that he made this concession means his legal and political advisors told him continuing would be catastrophic." But here's where it gets more revealing. The Justice Department's response to the Supreme Court decision showed just how badly the administration's legal position had collapsed. On January 2nd, 2026, just 2 days after Trump's concession, DOJ lawyers told federal judge April Perry that the government was seeking to settle all litigation related to the National Guard deployments. Translation, we want to end this case before the court issues more rulings that further limit presidential power. Legal expert Jeffrey Toobin explained what this meant. When the Justice Department seeks settlement immediately after a Supreme Court defeat, it means they know worse rulings are coming if they keep fighting. They're trying to cut their losses. The human impact was immediate and measurable. In Chicago's Pilsen neighborhood, Maria Santos watched the last National Guard checkpoint disappear on January 3rd. She told reporters, "It felt like our neighborhood could finally breathe again. We went from military occupation back to normal policing in 48 hours. In Los Angeles, restaurant owner David Kim saw dinner reservations in his deployment-affected neighborhood increase by 63% within the first week after withdrawal. Tourism officials reported that hotel bookings in previously occupied areas jumped by 48%. But the most significant impact was constitutional. For the first time in his political career, Donald Trump had been forced to publicly acknowledge that the Supreme Court could constrain his power, and that acknowledgement would have consequences far beyond National Guard deployments. Because now Congress knew that even Trump could be forced to back down when the courts said no. The reactions from Congress were swift, bipartisan, and absolutely unprecedented. Within 6 hours of Trump's concession, political leaders from both parties issued statements that revealed just how shocked Washington was by this constitutional moment. California Governor Gavin Newsom didn't mince words. At 6:23 a.m. on January 1st, 2026, he posted on X, "President Trump has finally admitted defeat. About time real Donald Trump admitted defeat." Translation, even Trump's harshest critics were stunned that he actually backed down. Illinois Governor J.B. Pritzker was equally direct. He lost in court when Illinois stood up against his attempt to militarize American cities with the National Guard. Now Trump is forced to stand down. Donald Trump's lying again. He lost in court when Illinois stood up against his attempt to militarize American cities with the National Guard. Now Trump is forced to stand down. But the most revealing reactions came from Trump's own party. Senator Lindsey Graham, who has defended Trump through every scandal, every indictment, and every controversy for 8 years, told reporters outside the Capitol, "Today's development requires us to examine the constitutional implications of military deployment authorities. We must ensure presidential powers remain within constitutional bounds." Translation: even Lindsey Graham is preparing to distance himself from Trump's overreach. Senator Ted Cruz, speaking to Fox News, acknowledged what many Republicans were realizing. This Supreme Court precedent establishes clear limitations on executive military authority that all future administrations must respect. The court has spoken definitively on presidential power constraints. Think about that. Ted Cruz, one of Trump's most loyal Senate allies, just publicly accepted the legitimacy of a Supreme Court ruling that humiliated Trump. The mathematics of congressional reaction were striking. Within 12 hours of Trump's concession, 43 Republican senators issued statements supporting the Supreme Court's authority to limit presidential power. Not a single Republican senator defended Trump's deployment authority or criticized the court's decision. House Speaker Mike Johnson, who has been Trump's most reliable congressional ally, told CNN, "The Supreme Court's constitutional interpretation deserves our full respect and compliance. Presidential powers must operate within established legal frameworks." Translation: even the House Speaker won't defend Trump when the Supreme Court unanimously rules against him. Legal experts watching from Capitol Hill immediately understood the broader implications. Professor Jonathan Turley explained, "When congressional Republicans abandon a president on constitutional grounds this quickly, it signals that Trump's legal vulnerabilities extend far beyond this single case." But here's what nobody saw coming. The concession didn't just affect Trump's relationship with Congress. It fundamentally altered how ongoing investigations and pending trials would proceed. Former federal prosecutor Barbara McQuade explained the connection. When a president is forced to concede constitutional authority by the Supreme Court, it weakens his position in every other legal proceeding. Prosecutors and judges now know that even Trump can be made to back down when courts rule definitively. Within 72 hours of the concession, 3 separate federal prosecutors filed motions in Trump-related cases, citing the Supreme Court's National Guard ruling as precedent for limiting presidential authority claims. The January 6th case, prosecutors filed a brief arguing that if Trump lacks authority to deploy troops domestically, his claims of absolute presidential immunity become significantly harder to defend. The classified documents case, prosecutors cited the ruling to argue against broad executive privilege assertions. Congressional investigators immediately recognized the precedent's value. House Judiciary Committee ranking member Jerry Nadler announced plans to subpoena Trump administration communications about the National Guard deployments, arguing that if the deployments were unconstitutional, Congress has oversight authority over how that decision was made. Let me tell you about Professor Sarah Williams, who teaches constitutional law at Georgetown University. Professor Williams told her students, "This is what constitutional accountability looks like in real time. When courts check presidential power and Congress responds appropriately, the system works exactly as the founders designed it." Her students asked whether this would affect Trump's other legal battles. Professor Williams replied, "When the Supreme Court unanimously rejects a president's authority claim and Congress accepts that rejection without resistance, it sends a clear signal to every other court handling Trump cases. The signal is simple. This president is not above the law." The human impact stories continued to emerge from affected communities. In Portland, community organizer Janet Rodriguez told The Oregonian, "Seeing Congress acknowledge that those deployments were wrong makes us feel like our constitutional rights matter. When even Republican senators say the president went too far, it validates everything we experienced." But the most significant congressional reaction came from an unexpected source. Senate Minority Leader Mitch McConnell, who rarely comments on Trump's legal troubles, issued a statement that shocked political observers. The Supreme Court's ruling reaffirms that presidential authority operates within constitutional constraints. All branches of government must respect these boundaries. Translation: even McConnell won't defend Trump when the court rules unanimously against him. And here's the accountability question that Congress now faces. If a president can be forced to concede constitutional authority when courts rule against him, what does that mean for every other claim of executive power currently being litigated? This Supreme Court precedent just changed the constitutional landscape for every future president. And the implications go far beyond National Guard deployments. Legal scholars are calling this the most significant constraint on presidential military authority since the end of the Civil War. Professor Lawrence Tribe of Harvard Law School explained. This ruling establishes that presidents cannot simply declare domestic situations require military intervention. They must identify specific legal authority. That is a constitutional game changer. Think about what this means for future presidential power. Any president who wants to deploy military forces domestically now faces the burden of proving legal authority under existing federal statutes. They cannot rely on vague claims about federal interests or national security threats. The precedent applies to far more than National Guard deployments, immigration enforcement at the border, disaster response operations, even protection of federal buildings during protests. Every military deployment must now meet the constitutional standard the Supreme Court just established.